We are live back in Senate Judiciary. We are taking up S-178 again, the speed trial bill. We have Judge Zone joining us. I believe. There it is. Morning, Judge.
Good morning.
Can you turn the volume just a little bit? So, Judge, I'm just hoping to get your thoughts on this bill in general. I have a few questions for the committee. Hopefully the committee will have some questions too, and just wanted to get your perspective and take it from there.
All right, so good morning. Tom Zone, Chief Superior Judge. I did have a chance to see the testimonies from yesterday, and if it's okay, the first thing I wanted to address, Senator Baruth, you had a question about essentially the judge, I think your word was ignore. If a motion is filed, can it be ignored? And the short answer to that is no. We have policies in place that when a motion is filed and it is ripe for determination, that term is called under advisement. When a motion goes under advisement, we have monthly reports, and I get a copy of those reports. The judges get a copy, and we have a policy that says within 90 days something has to be decided. That's the outside. It is our expectation that motions and filings are decided well within that time, but that's the outside. And so that is not something which should happen ever. We have procedures in place and policies in place to make sure that nothing gets ignored, that everything gets addressed.
Thank you, Judge, for that. I'm wondering, so I'm assuming then you support the permissive language there that says a judge may respond as opposed to a judge shall respond? I
think may works. It gets you to the same place because a judge will respond. That's what we know.
Thank you.
When I looked at S-178, and I understand that it's based in part upon Massachusetts Criminal Rule 36. There's a distinction between the two, though. The bill S-178 well, let me do it this way. Massachusetts Rule 36 talks about we have a timeline. If you don't meet the timeline, if the case is not tried, commenced within that timeline, the defendant is entitled to have that case dismissed. And then it has exceptions for what takes things out of that timeline. It doesn't have an analysis of interest of justice factors. It doesn't have the court addressing whether their victim input. It doesn't have the court addressing prior record, anything like that. It's strictly time. It puts the burden on the state to show basically that the time, if you will, has not run. S-178 takes components of that and puts it into what we have for what's called Rule 48, and I think the committee's heard about Rule 48B. Rule 48B provides that the court can dismiss a case if it finds it's in the interest of justice and the effective administration of the court's business. And Eric Fitzpatrick talked yesterday about the Sauvé factors that the court would have to look at. And those are essentially, those factors are taken and kind of in S-178 added to the Massachusetts provisions. And so what in Vermont, this bill would say, unlike Massachusetts, if you have something that's been pending for in excess of the requisite time, you can file a motion. It doesn't say you are entitled, like Massachusetts, that the outcome is preordained. It says you can file a motion. And then what the court has to do with that motion, the state has to respond within 14 days. And if the state doesn't respond, the court then has the opportunity the court may dismiss it. But if the state responds, the court has to then look at a number of factors which mirror the Sauvé factors and also address the time factors from the Rule 36 down in Massachusetts. That's a lot of work. It puts a lot in there because what it talks about is if we don't meet the time standard, you, the defendant, if the state doesn't meet it and the case isn't heard, the defendant may file a motion. Well, right now, the defendant may file a motion after 6 weeks, or after 1 week, let alone waiting a year. So the bill doesn't really give the defendant anything that they don't already have in terms of the ability to file a motion. It does have provisions that could potentially lead to different results if the state is overwhelmed, as we heard they said they would be, and can't respond to everything. And then the court dismisses it because there was no response. And so it's very different than the Massachusetts bill, because this will cause, the state is correct, this would be a lot of work. As currently structured, the Vermont bill doesn't say what the filing has to contain. It says the defendant can move. So I think Ms. McManus yesterday referenced what would essentially be a pro forma, I think she said 2-sentence filing. The case hasn't been brought within a year, it should be dismissed, something like that. She's correct insofar that the bill doesn't say that the filing itself has to affirmatively outline the exceptions for what was taken out for the timelines, competency, whatever the other issues may be. And so that's something that a judge might do if this bill were to pass, and say, well, no, when you file a motion in this court, you have to establish that you're entitled to it and that you have met the year. The state doesn't have to establish that you haven't. And so I point that out because if the committee wants to go forward on this bill and try to tweak it, you would want to make it clear, what is that initial burden? Is it really so easy to just file a 2-sentence that then puts the burden completely on the state, as the state was asserting it may be? Or is the intent to say the defendant files something that shows they're entitled to make a prima facie case that it's over a year, and they're entitled to file this motion for dismissal, and then the state has to respond? And then who has the burden of proof? Under the Save case, the defendant has the burden of proof to establish that it's in the interest of justice for dismissal and the effective administration of the court's business. This bill does not get into where that burden goes specifically, and I heard the testimony and the questions yesterday that the intent may be to say that the state has to file and establish that it's not, that dismissal would not be in the interest of justice or the effective administration of the court's business. And so that would be some language that you would want to look at to try to focus as to exactly where is the burden and how is that burden established. But this bill as drafted, it creates a process with a lot of rules and a lot of exceptions that someone's going to have to go through. One of the exceptions that I note is, and it's the same as in Massachusetts, one of the exceptions says essentially you exclude time from other cases waiting for trial. Well, what have we been talking about for the past year or so? That's individuals with multiple cases, 5+. So we know that there's going to be a number of individuals where these cases are excluded because we can't try every case at once. Generally, one case goes to a jury's there for 3 months. So in theory, if you have 4 cases, it would take no less than a year to try all those cases because you can't go to the same jury for each one. And so I think there's some issues like that as far as excluding time that would come up practically speaking. And I have not checked it with Massachusetts colleagues or looked into research in Massachusetts as to how that has played out. The rule in Massachusetts is a rule of case management, administrative case management. That's actually how it is phrased also. It's criminal procedure rule 36 : case management. This S-178, it's an attempt at case management, but it's also an interest of justice. Again, it takes us right back to that. If we have to consider the same factors as we have in Save, we're looking at the interest of justice, and it's not just a speedy trial act. It's an act of speedy trial and interest of justice. So it basically combines the two things that we currently have in Rule 48. It combines that with a speedy trial component that Rule 36 down in Massachusetts has. Any questions?
Senator North.
Yeah, Judge Zonay, I understand the reason for the bill, but in your opinion, my concern would be the backlog as it exists today, and this is the second time we've heard that this will put more burden on the state or whatever else. How do you think that this would affect the backlog, if any?
That is a question that I've been wrestling with. If you assume that there are a number of filings made and the state doesn't respond and the court can just dismiss cases, backlog is it's gonna help. That the matters would be able to have cases dismissed. If you assume that there's going to be a motion filed, the state will oppose it and require the court to engage in the analysis that's set forth in the bill of not only the time standards, but also the standards as far as the other factors, the SABE factors. It has the potential to take what is intended to be able to move through cases quicker and start adding more cases for us to have to address and divert us. So instead of addressing the case and getting it heard, we're addressing the dismissal at a heightened level. And so, again, a defendant has the right today to make that filing. And there's a difference. There would be a different potential answer to that if it was a strict speedy trial, as opposed to with all the factors in it, because it's not as much. Did you hit 12 months in one day? If the answer to that is yes, the case is dismissed. That's Massachusetts, as I understand it. Something like that could help the backlog. It's pretty clear. Now, of course, what would be, I think the challenge will be looking at all those exceptions and trying to wade through them and having arguments over, well, this is accepted, that's not, and where the time is. But there are some cases that I don't think that would apply. And so it would make it clear, and that would have the potential to address them. But I think there'll be a lot of cases where you're addressing the situation of the factors and the interest of justice factors. So it does have the potential. If I don't think the way it's written now, it would lead to the type of result that is intended. I do think it would lead to a lot of work and the potential for more court time on these types of cases. But again, that's because of the structure.
Yeah, so just general comment. I think, one of the things that I've been grappling with since we started this is the idea of automatic dismissals weighed against giving the state the opportunity to say why a certain case actually should continue staying on the docket. And I think that it is fair to have that opportunity for the state to say, these are the reasons that we need to, that this case has been lingering for so long. But yes, then in addition, you have the workload that would be added onto it. So I guess that's just a general comment. I guess, and the other thing I wanted to clarify my own understanding here is I do agree that the defendant does have the right to make such a filing right now. My understanding is, though, that the burden is on them to prove the interest of justice, and they're not filing 2-sentence motions; they're filing 5 or 10-page motions that are 48B motions. The intent that I'm trying to get at here is, or the goal that I'm trying to get at here is, once the case has been lingering for such a long time, the burden then flips, if a motion is filed by the defense, the burden then flips onto the state, in essence, demanding an explanation from the state as to why they believe that the case should continue staying on the docket. So I guess I'm not sure that I have a question in that, but if you have any response, I'm happy to hear.
You are correct. This bill does go in the direction of, for this category of cases, flipping the burden from the defendant under the SABE case. And I see Eric has come into the room under, we're going to say Fitzpatrick today, under the Fitzpatrick case. Little, and I don't know if Eric is aware of this, but I was actually trial counsel and appellate counsel in the Fitzpatrick case, so I'm very familiar with that case.
No, I did not know that. Thank you, Judge.
Almost 25 years ago. I'm getting old. Senator Hashim, your goal is, it goes in that direction, yes. That this flips it, but the way it flips it, it still adds a lot of work, and there's a lot there. I mean, we heard yesterday the issue of, well, judges can dismiss cases, and the reality is that it's up to the executive branch to decide what cases to prosecute and have ownership of the cases that they decide to prosecute. There are exceptions where the court under Save in our state is permitted to have dismissals, but as we saw up in Franklin, which was discussed yesterday, what happened there was the judge got together with the state's attorney. They talked about it. My understanding is a list of cases that they felt they, if you will, didn't need to go forward on. The court then did an order saying we're going to dismiss all these unless you object. The state was essentially on board and made objections to some. My belief was that the cases that the state said, no, we want to go forward on, these went forward and weren't dismissed, and the others were dismissed. And so there are mechanisms in place where if the state looks at its docket and has cases that are 5 years old or 4 or 3 years old and says, well, do we really need this unlawful trespass from a business that is now closed and we know we're not going to bring a witness in? Now, the state has the ability today to dismiss those cases. And I think the reticence in Mr. Valerio or Mr. Paul, whoever talks to you from the defense side, I think they're better suited to talk about why we're not seeing more of these motions. Because as I started off with Senator Baruth's question from yesterday, if we have these motions being filed, they will be addressed under Save. So if we had an onslaught of motions from defendants saying this needs to be dismissed under the Save factors, under Rule 48B2, the courts will be addressing those.
I think, not that I'm speaking for the Defender General, but my own perspective here, I think that the 48B motions are quite difficult to prove. Has that been what you've seen? Because it's my understanding that it's considered extraordinary relief to dismiss a case in the interest of justice.
Well, over the objection of the prosecutor based upon the separation of powers. And so a bill like this brings in the questions about separation of powers and those types of issues. In the Fitzpatrick case, it was then Chief Justice Amistoy dissented, and he talked about that he was aware, he recognized that Save was the law of the state of Vermont, but he also then said, but basically his position was it's up to the prosecutor to prove the cases, and the court shouldn't be doing that. And so it has to be very extraordinary, exceptional circumstances where the court does that. But that does happen. There are judges who have dismissed cases under Rule 48 for, we'll call it the minor cases, delay on the docket, things like that. So that does happen. Does it happen with a frequency where I can say it's a regular occurrence? No, I don't believe that that's what occurs. But every case is different. And if there is a filing, I think that the courts have to take a close look at it. I also think that it's important for the state and defense to have discussions about cases to say, are there cases that we can both agree might be better to not have in our file cabinet so that we can focus on the other cases? And those are discussions that should be undertaken. And to the extent the court can assist in providing opportunities for that, I think that's important for us to do.
One other question that I had in terms of the workload. I mean, I agree that there would be added workload onto the state, but one possibility regarding the calculation of time, delays that may have happened as a result of the defense or the state. What do you believe that it would somewhat even the scales if the responsibility or the burden was on the defense to include the calculation of time and to include an analysis of whatever delays have happened and to then conclude that we've met this certain timeline.
That's
And
a
there-
function, that's a function of what do you want a bill? And this is a question for policy for the committee. Do you want a bill that says we hit this time frame? The state just basically has to send in a pro forma letter saying, yes, we want this dismissed. It's over a year with no backup. Or do you want a pleading that says we have been over a year and we've analyzed it and it's a prima facie case. We the defense can establish that it's been over a year and therefore we go forward. It's really a policy decision. Where do you want that burden to lie? Oftentimes the burden is on the filer to establish on the pleadings that they are entitled to the relief they seek. And so if you structured it that way, that would not be inconsistent with other areas of the law where you have to show on the face that, yeah, you're entitled to the relief that you're seeking. And so in that case, if you structured it in a way to have the defense have to affirmatively represent that there are none of the exceptions apply or whatever it may be, that may be a way to address it. But that's a policy decision.
Committee, any questions or comments? Senator Norris?
Yeah, I do have one, Judge. As we all know, Franklin County initiated the 48B hearings, and why are other judges or counties not doing the same thing if it would alleviate the backlog and the courts? And I don't know how much more time or personnel they needed to do just this, but they eliminated, the better part of 300 cases on the books, I believe, up in Franklin County. So why aren't we pushing more in that direction?
The role of the court is to serve as the neutral arbiter of disputes. And there are some who would, I know that when Judge Maley did that, there were some who felt that the court was reaching out too far. Others felt that that's exactly where the court should be. And our role is to administer justice. And so I think that there can be differing views among judges as to how far they want to go down that road of aggressively bringing that docket in and saying, I'm going to dismiss these cases unless. And I think that in some counties, the culture has worked well where the parties are engaging in those discussions and the judge doesn't have to do that. And so the absence of other courts doing that is not necessarily a reflection of a need in a county that's not being addressed. It may be a reflection in some counties where the state's attorney is already taking steps proactively to address things. So you don't need to go to that mass dismissal aspect. But there's different factors in every county on how the prosecutor and defense, the judge, how everyone interacts on these types of cases. And so I can't say there's one specific reason why it doesn't happen. I know that there's been a highlighted, when I send this bill out to the judges and say this is a bill that's being discussed, one would think that, and with the state's attorneys and defense bar, I think this will, nothing else happened on this bill after today. I think that the fact that you have brought this forward and have had hearings on it and are going down this road, at least so far, has the potential to have the state defense and the court and the judges, everyone looking at things freshly and saying, okay, what can we do to kind of go in a direction that's going to address the backlog that maybe it's not quite what S178 was looking to achieve, but that can address the backlog in a more, I'll say, global manner.
Thank you. Committee, anything else?
No, Bob took my question.
Wondering if we might be able to speak a little bit on the Administrative Directive 24 and where those timelines were developed?
The Criminal Rules Committee, there was two ways they were developed. Many years ago, there was the National Center for State Courts that came up with standard guidelines called disposition guidelines for what should it take to resolve a case for the average case, knowing that some would be longer and some would be shorter. But what would be an ideal time? And years ago, Vermont adopted administrative directives that address those timelines. I think it was based upon the National Center for State Courts guidelines that were put out. A number of states went in that direction. When the pandemic hit, there was questions about what were realistic guidelines. What we know about case flow management is that if you have unrealistic guidelines, it's not helpful. So you need something that's realistic. And so we an analysis was done on the guidelines. It was twofold. One, Lori Canty and I did a survey of all the judges and as to what they thought would be appropriate guidelines. And we came up with some guidelines that we thought for the misdemeanors and felonies and how they should be categorized. At the same time, what also happened was the Criminal Rules Committee and Criminal Oversight Committees, they did an analysis of what should be the guidelines, studied data, they talked to judges, they looked at cases, and it was a deep, deep dive into the guidelines. They came out with basically what Lori and I had also come out with. In other words, everything came together. So after the deep analysis, what the Supreme Court did was it amended the disposition guidelines based upon what was recommended by the Criminal Oversight Committee, Criminal Oversight Subcommittee and Committee, as far as how we should handle the guidelines. And so those guidelines were put out. They are not a Speedy Trial Act type guideline. They are intended to say, here is your goal. Here's what you're going to try to do. The Supreme Court has held that if you don't meet those guidelines, it is not a basis for dismissal. And so they're aspirational, and we try to meet them as much as possible.
Thank you. Committee, anything else? All right, Judge, thank you very much for testifying on this. I think there's obviously not going to do any markup today or anything. I think we're going to chew on this for a little bit and think about what potential changes we could make. Obviously, want to get some more testimony from the defense perspective on this and see what, if anything, we can do. Yeah, so thank you. Yeah, you're doing better.
Have a great day.
Great. You have still live. We're gonna take up some other bills. Yeah. 186 is over.
Yeah, I think that's exactly.
Which one did you want to start with?
Oh, how about, let's go with 186. 186, that's okay for you.
Okay. So 186, sorry, committee assistant is grabbing copies of the bills right now. So
What number are we doing?
186. It was a last minute change since I figured that didn't want to let us go too.
No, I appreciate that.
Yeah.
Oh, I'm sorry.
These are both of these are
You made that sound so good wise.
both of these are pretty small bills that I consider to be impactful changes based on what I've seen over the last 8 years.
We don't have the text.
Yeah, there we go. Great, thank you. You can pass these down. So 186, this is the one that that I know Eric is gonna be able to explain, much more fluently than I can. It has to do with plea agreements and,
Is there two?
yeah, so we're getting 186 and 203.
Oh, that, 30 or 186. Yeah. We're good.
Okay.
186.
Thank you. So it has to do with plea agreements. Has to do with plea agreements that may get kicked back and forth from criminal court to juvenile court, even when the juvenile wants to take an amended plea from a felony to a misdemeanor. And as a result, it ends up getting kicked back to, I guess you could say, the disagreement sometimes all parties, because they want to resolve it in the manner of taking a misdemeanor versus a felony. So this is just one example. This is an attempt to address that. It's, in my opinion, a technical change that is, if we're not going to pass this bill necessarily, it's likely to get tacked onto the miscellaneous judiciary bill, which is starting in the House this year. But I figure we can just take a walk through. That way, we'll have it in our minds once we either get to the miscellaneous bill or if we just want to pass this. So, Eric, if you'd like to take it away.
Sure, will do. Thank you, Senator Sheehan. Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel here to do a walkthrough with the committee of Senate Bill number 186, an act relating to the jurisdiction of the criminal division over plea agreements and proceedings related to juvenile offenders. As Senator Sheehan was mentioning, this has to do with plea agreements and the way cases sometimes move back and forth between the criminal division and the juvenile division. Just a quick minute or two of background, which I think will help everybody understand what the intent of the proposal is. I'm sure you recall from the years of dealing with this issue in this committee that whether an offense against a young person starts in the family division or the criminal division depends on two things: how old the young person is and what offense it is. Right. So, turning to the what offense it is question first. Remember, that brings up the question of formerly Big 12, now Big 14. That's this concept that when the young person commits an offense that falls in that list, now it's two lists, which I'm not speaking totally hypothetically, here is the list. And if the young person commits one of the offenses on this list, now referred to as the Big 14, then that means the case starts in criminal division. So these are a list of the more, as Senator Sheehan was saying, some of them there are felonies, and that's not all felonies on the books, but these are felonies. And you'll see there's 11 on the first side of the piece of paper that you're looking at, and if you turn it over, there's 3 more. And that's thank you. And that's your total of 14, your Big 14 offense to start in criminal division. And I think you bet. Actually, you don't need to surprise anyone with a pop quiz, but does anyone remember why there's 11 offenses on one side and 3 offenses on the other? What's the one distinguishing factor between those, the 11 and the 3?
One number, age.
Ah, exactly. It's age. So for the first 11 on one side, it's a young person age 14 and up who commits that offense, starts in criminal division. On the backside, those 3, remember, aggravated stalking, drug trafficking, and
Using a
using a firearm. Yes, exactly.
while committing felony.
While committing felony, exactly. And those were added 2 years ago. And sort of, you may recall that a legislative compromise, the position of the Senate at that time was to expand the Big 12. The House did not want to expand the Big 12. So the compromise position that was reached was to add 3 offenses essentially to the Big 12, but they don't start at 14. Age 14, like the 11 on page 1, it's a smaller group of people because it starts at age 16. So side 1, any person 14 years of age or older who commits one of those offenses on the first side, will start in criminal division. But someone age 16 years and older who commits 1 of the 3 on the second side would start in criminal division. So that's your background. Now, That's where these offenses start. So let's say, for example, let's just to pick one randomly. Let's say on the first side, number 4, aggravated assault. So where does that case start against a person 14, 15, 16 and up? It starts in a criminal division, right? But let's say, Senator Sheen was alluding to this, that there's an agreement among the parties that the person is actually going to plead to simple assault. Simple assault is not one of these offenses that starts in the criminal division. So if they're going to start over and the person has to plead to a new offense, that's got to move back down to the family division because that's not in the jurisdiction of the criminal division for a child that age. Everybody see that in reality? That's what's led to the bill. The bill permits, and again, important point here, permits, not required. This is something that the young person can elect to do. Obviously, it can be with the advice of counsel. But the young person can choose if they're, again, just using our hypothetical, but would apply generally. Persons in the criminal division, they could charge with aggravated assault. They are choosing to plead guilty to simple assault. They can choose to have that stay in the criminal division and have the plea agreement resolved there, rather than have it transferred back down to the family division, which entails more time, more expense. But again, there may be reasons that the young person would rather do that. Maybe they'd rather have their offense be in the juvenile division because of a criminal record, because of the other things that are benefits associated with a family division and juvenile plea, and that's fine. They can still choose to do that. But in those cases where everyone's on board and they decide they want to plead in the criminal division, this permits that. That's it in a nutshell. So
Yes. When you say they at age 14 and up.
yeah.
When you're referring to, they may want to take that. Who are we actually referring to? The 14-year-old or mom, dad? Who's making that decision? Can a 14-year-old make that decision?
With their attorney.
With their attorney, without any parental.
Well, they would have a guardian ad litem appointed.
That's what I mean.
Yes,
Somebody else is involved.
yes, they're all involved in that discussion. Exactly. Yes.
But they have, as the defendant, they have the ultimate.
Files
Their parent can't overrule.
That's an interesting question. I think that it is up to the child and their attorney with the advice of, but if I'm misspeaking on that, maybe you want to check with the juvenile offender or someone just to confirm that that's the right person.
These are instances where children have been charged as adults, yes?
Exactly.
So if we're charging children as adults and assuming they have the capacity to act as adults, wouldn't we then give them all the rights of an adult? Thus able to make their own legal decisions?
I think that again, if you're in the adult sort of policy column, you in one respect, but in the maybe the current structure of the statutory scheme is that they are still minor in the adult criminal division. So, but I think that it's true that the ultimate decision is theirs, and with consultation of the parties that we mentioned.
Do they have to be provided a lawyer?
I believe the answer to that is yes.
So,
Yeah.
Any reflections? Thoughts? Okay.
Just a sort of technical piece. So just in case he ever comes out, I haven't noticed this, but someone might notice, hey, isn't the exact same thing written on here twice? The answer to that is yes. The same provisions do appear twice. Sections 1, 2, and 3 sections 1, 2 are identical to sections 4. 4 and 5. And the reason for that is that it's the delayed effective date of in a sense, it's correct.
All right. Thank you.
Yes, you're right. This has to do with age because the age, which is raise the age, doesn't go into effect until July 1st, 2027. Remember, that's the agreement you guys reached last year. So because you have another set of laws out there that have a delayed effective date of July 1st, 2027, you have to make the amendment in both places. If you want to, otherwise you get all messed up when 2027 rolls around. You have something go into effect. If you didn't make the change to that too, and would say you didn't make it to this, then you'd have two different laws on the books.
And
They're generally not good.
past history, I would have an asterisk about whether it will go into effect in 20.
Of course, yeah, it's played it safe from the drafting perspective. Yeah.
One follow-up question on this. So at the age of 14, if in fact they do plead to become a felony death with misdemeanor.
Right.
More important.
Yeah.
At some point in time, is that off their record? That misdemeanor?
That has to do with the ceiling, if that's kind of what you're asking about. The ceiling statute may provide for that depending on the nature of the offense. I'm not the attorney who covers stealing, so I'm not positive if it requires a motion or is it an automatic process. I tend to think that it requires a motion to get skilled. So that is an option at a certain point in time. But that is one of the calculations that a person would have to make as to whether to go in the criminal division or the family division. As the family division, it's automatically single once you reach age 18, currently potentially 19 in 2027. Whereas in the criminal division, it's not automatic. It's part of the understand. It could be done through motion, but that's a benefit of the family division juvenile case. If you choose to go that route.
Anything else? That's great. Thank you, Eric.
Yeah, sure.
We can switch gears to one that I think is a bit more straightforward, which is S203.
Right.
And this has to do with essentially very technical change regarding when when you can consider that somebody is being charged with a DUI number 2, if the first DUI is within 20 years, but there are some issues with when that start date, with when the date starts for, I'm not doing a good job surrounding my own bill here. So statute of limitations for when you can charge somebody with DUI number 2. And Eric, if you just want to explain it, that would just be.
So I think you put the issue on the table, though, Senator Schuman. That's exactly what it deals with. It's subsequent offenses for DUI is the nature of the bill, and it really is dealing with. Back up for just a second. The penalties for DUI increase for subsequent offenses, right? So if you look at just to see kind of what they are now, if you look at page 2. I hope everybody has the same version. Like if you look at page 2, line 2, for example, do you see a $750, 2 years?
Yep.
That on line 2?
Yep.
All right. So that's the penalty for a first offense. Fine, $750, prison for not more than 2 years. So it's a 2-year misdemeanor if that's number 1. Second offense starts in subsection C. Look down at line 7. Bumps up, goes from $1,500, still a 2-year misdemeanor, but the fine is higher. And you'll see lines 8 to 12. It also details some mandatory community service for incarcerated time. So that's how the penalties bump up for a second offense there. Third offense, line 13, you see there, well, then you're bumping up to a felony. Look at line 16 and 17. Comes $2,500, but prison not more than 5 years. Then you're talking a 5-year felony for third offense. Lastly, on page 4, fourth or subsequent offense, and sorry, it's on page 3. You see it on line 10. If it's a fourth or subsequent offense, it becomes $5,000, 10-year felony. So you see this stepped up gradation system here. However, the key here to one of these prior offenses, it's not a prior offense, no matter when it occurred. It has to be. If you look at the language, trying to look at the existing. Imagine the strike that wasn't there. Let's say on lines 4 to 6 on page 2. It's a person convicted of violating DUI. That's for section 1201, who has been convicted of another violation of that section. Let's imagine for a second what the current language is. Within the last 20 years. See? So you're prior. It's not, let's say you're prior, let's say you had a DUI 25 years ago. That wouldn't count as a first offense. It has to have been within the last 20 years. So in a way, it's almost allows for an automatic cleaning of your record of prior offenses if you've gone 20 years without getting it up. That makes sense, sort of the intent, the way that is supposed to work. The issue that has come up, as Senator Hashim has alluded to, is, all right, so that's a case. That's when your first offense was 20 years ago. When does that subsequent offense start to count? In other words, when do you say, all right, it's from this moment that I'm going to count back 20 years? And right now, the way it's written, you see it's line 4. It's the same for each offense, but let's use the second offense as an example. Line 4, page 2. A person convicted of violating section 1201 who has been convicted of another violation within the last 20 years. So you start counting back, at least arguably, under that existing language, at your conviction today, right? A person convicted of violating who has been convicted of another violation within the past 20 years. So you start, let's say I got convicted today, January, where's today? Trying to give myself a happy day there, get my prior conviction off the record. Yeah, but so you start on January, you count back 20 years. And if you have that prior during that period of time, then it counts. But if it was more than that 20 years, that doesn't count. You see, though, what could happen here is that the moment when you committed the DUI offense out on the road, when you got rep tested or when you got arraigned or something like that, there could be a pretty big gap between that time and my conviction now, right? And that might add up to more than 20 years. Mm-hmm. So the proposal is to say, rather than looking back from the moment of the current conviction, you look back from
The violation.
Exactly.
Yeah.
That's exactly. Right. Start counting back from violation.
You're basically you just want to take out the time of the trial, right? You don't want to think that time of the trial is added on, right?
And any pre-trial procedures.
Right.
Because that could go on for a long time.
Right.
Too. Yeah.
Okay.
Yeah.
That makes sense.
So essentially, this makes it so it goes from the date that you did the thing, not the date that you were held accountable for the thing.
Exactly. Exactly.
And especially those backlog, which could these days add 5 years.
Oh, I see. It could go on even longer. The case could proceed even longer.
Yeah. I think this is a great change given where we are.
It's from the date of the alleged violation.
Mhm.
Because DUIs take 6 months to whatever,
Right.
depending on what happens. So you can come in at 19 years to 6 months and exceed that 20 years with the case being dragged out that long, all of a sudden that 20 years gone. Even the date of violation in itself, 19 years to 6 months, that's the date he violated the section, correct?
Mhm.
And I think that fact pattern has kind of, has happened, and that's kind of where this bill's coming from, if I understand correctly.
This is refreshing my memory of my conversation with the state's attorney from Wyndham County. So very helpful. Thank you.
Yeah.
Any other questions or comments? Straightforward. Eric, did you have anything else?
No, I think the only thing that, if you hear from witnesses on it, would be an interesting question is if you do use that date of the violation, is that the right date to use? In other words, should you use, the date that the person was arraigned, maybe, or the date that the information was filed? Was it better to use that date of the actual? The only reason that occurred to me was because what if the charges dropped or something? But maybe you still use that. A better question for your witnesses. See what's the exact right date to use? I don't know.
If the charge is dropped, why would it still be on your record? At all?
Exactly.
Yeah, I guess that's true. That's right. Because even if they had charged as a second offense, if the charge is dropped, it would be moot, so to speak. Right. Well,
Drop or not convicted, 6, 7 months, that doesn't matter.
right.
The date of the violation becomes a play, in fact, they're found guilty of violation offense.
Right. Yep. Well, then that tape record was drafted very well.
You did an excellent job.
Yeah, well, I want to make sure, what you just said, I want to make sure, just confirm that, just in the event that somehow, somebody isn't convicted, still has it on the record. I don't want it to end up being used against them 20 years if it is dismissed. Just want to confirm that, and that should be pretty straightforward. All right, anything else? Sarah Mavis, do you want to, I'll get the other bills you want?
Oh, keep going. We got time. We got
All right,
time.
we can,